So I'm joined today by the Right Honourable Lady Dorrian. Good afternoon, Lady Dorrian. Thank you very much for joining us.
It's a pleasure, Edith.
Okay, we are going to have a chat about the Cross Justice Review Group that you chaired in relation to sexual offences and suggestions, proposals that has arisen from that. So I wonder, just to start things off, could you outline for us why the review was set up, who was involved, and what it was tasked to achieve?
Yes, well, the reasons behind the setting up of the review group stemmed from the significant increase that there has been, you'll be familiar with this, in the prosecution of sexual offences in the High Court, but also in the Sheriff Court. And a sort of general increase anticipated in serious organised crime in the High Court. Sexual offence cases have also become more complex, partly to do with the nature of the cases themselves, partly to do with the number of historic cases which come within the system. And there was a feeling that if nothing was done, the system was likely to become stretched and there would be increasing dissatisfaction with it. In addition to that, it was felt that despite improvements over recent years, including legislation, but also including other initiatives and pilots that have been developed, including the practice note number 1 of 2017 and so on, there were still aspects of the way in which these cases were dealt with that could be improved. And that was apparent actually from the experience of virtually everybody on the review group. You asked who was involved, and it was a complete cross-sector group. There were representatives from the defence, both from the bar and from the solicitor profession, from the prosecution, but also third sector, Scottish courts, judges, sheriffs, right across the whole sector. The fundamental aim, and this is referred to in the report in the terms of reference, was to improve the experience of complainers, but without compromising the rights of the accused. And in pursuit of that objective, we asked ourselves how best we would achieve a modern system which was efficient, affordable, future-proofed, but met that fundamental aim. And that we decided from the outset to take a clean sheet approach to this and not be hidebound by the way things have always been done or anything like that. So that basically is the general background.
Okay. And the review paper identifies 6 main areas, with the main recommendation, I suppose, being the establishment of a brand new national specialist court to deal with serious sexual offences. Could you outline for us why that's being recommended and how it will work in practice?
Yes. Well, the review group felt that there was really pretty overwhelming evidence from across the globe that a specialist court was the way forward, and that if we introduced a specialist court in Scotland, that would address almost all the concerns which had been expressed to us in the course of the review, and which members of the review group, whether they were defence or prosecution or judges, had all, to one extent or another, seen, experience of. And it was also felt that there would be commensurate benefits to the accused and the criminal justice system at large, and the public's confidence in that, if we developed a specialist court to deal with these particular cases. So the proposal is that all solemn sexual offences, whether they would currently be prosecuted in the High Court or in the Sheriff Court, should come within the jurisdiction of a new specialist court, of which the judges will be both sheriffs and High Court judges, who will be, and this is the critical thing, they will be specially trained in trauma-informed practices designed to avoid re-traumatization. The court procedures will be developed with those practices in mind. the staff, the macers, the clerks, so on, jury minders will have such training as to the degree necessary. And those appearing in the court will have to meet certain standards of training to be specialist pleaders in the court. The other important element of it is that the default position will be that the evidence of complainers should be captured in advance by pre-recording, usually by commission that will be, and that there should be an extension of ground rules hearings beyond the current use for commissions to cases where, should it be necessary for a complainer to give evidence in person, there would still be a ground rules hearing. And the type of enhanced case management that we've seen develop in the PH court would be adopted for cases generally. That's more or less the outline.
All right.
Obviously, it needs legislation. And so, as with any of the recommendations which either require legislation or the development of a pilot, the precise detail will have to be the subject of future consideration and consultation.
All right. Just looking at a couple of the things that you mentioned there,
yeah.
One being the pre-recorded evidence, and
yeah.
the practitioners are seeing that being used more and more. And I think probably, as you've said, everybody across the board of your review group and also in general would agree that the complainers should be treated better. And I can't imagine anyone thinking that particularly vulnerable people shouldn't have that assistance or just be treated
yeah.
better in general. So in terms of the pre-recorded evidence itself, I understand that the aim is to capture very early on the evidence of the complainer. Could you explain a little more about how questioning on behalf of the accused is hoped to be achieved, and at what stage would it be, as is currently happening at a commission stage, which could take, usually around about a year later, or is there something much earlier than that?
The idea is to try and bring this forward as much as possible. Essentially what we've done is we've endorsed the recommendations of the Evidence and Procedure Review on these matters, and you will, I think, be familiar with the recommendations that review made, and it was clear to us, as you've touched on, really, that pre-recording of the evidence of a complainer so that their involvement is over would, at a stroke, really resolve about 85% of the issues that were reported to us as causing likely re-traumatization or potential for re-traumatization. The Evidence Procedure Review recommended two separate schemes for children and for adults, and we didn't really focus in this review on the issue of children because that's something which is the subject of other initiatives already being taken forward, and with the first steps towards that being achieved in the 2019 Act in relation to children. So our focus was on adults, and the recommendation really is that the evidence should be captured at as early a stage as possible. It would be anticipated that with appropriate training of the police, the initial statement could be captured in a video recorded statement, which would become effectively the evidence in chief. If any more were required, then a brief commission for that could take place. And then any cross-examination would be in the form of a commission in the same way as now, but at a much earlier stage, if at all possible. Now, you're going to say to me, disclosure, because I fully appreciate that that is actually the main handicap, if you like, towards achieving that. So we have made other recommendations in the report about improving the efficiency of the system generally, and improving communication between the defence and the Crown, with an earlier identification of the advocate depute, which we hope would enhance disclosure and things like that at an earlier stage, so that the Commission could be brought forward to a much earlier stage. I think in reality, even as we speak, it should be possible for commissions to be dealt with at an earlier stage than they already are. But that's really all that's anticipated, that it will be a commission, it will be at an earlier stage, as early as is feasible, you know, as is commensurate with the defence knowing precisely what the case is all about, obviously. And to a large extent, that depends on the issues involved and the question of disclosure.
And I suppose I do remember Lord Carloway giving a talk a long time ago when these you know, these ideas were first being considered, and I think he travelled to the Netherlands and seen various models there, obviously with an inquisitorial system rather than an adversarial, and there was some hope of cross-examination even in amongst the initial taking of the statement. I can see difficulties with that, and I suppose
the recommendation for that was in relation to children, though.
Yeah, right.
The recommendation for that is in relation to children. That's what we called a level 1 recommendation. And that was as part of the Bairnshuis system, and work towards that is, I think, still being considered in relation to children. But that was not the approach to be adopted for adults. The approach to be adopted for adults was what we called level 2, which was a video recorded statement and then cross-examination by a commission by the lawyers in the normal way. So that level 1 issue only arose for children.
For children. But I suppose, as you've said, you know, resources, disclosure are all important, and presumably will take, if these recommendations are, or that particular recommendations is to go forward, that I suppose is the task of the Scottish Government to implement and resource that. The other thing you mentioned was also a single point of contact within Crown Office and Public Prosecution. So a kind of is that a kind of ownership by an advocate depute of a case in order that there's consistency and...
Yeah, I mean, it's not anticipated, I think, that the advocate depute would be the single point of contact. I think something there needs to be worked out between the Crown and third sector organisations. At the moment, I think that complainers have a number of sources of information available to them through via the Crown, by other support organisations if they're involved, and we felt that it was better for there to be just one source through which all the information is fed, that is a well-informed, properly trained source, which will not give either false impression or false information to a complainer, and will be able to get accurate information about the stage of the case and so on to provide to them. Communication was one of the things that repeatedly came up as a difficulty for complainers, and not just communication of information, but about the case, but about when will I get my phone back, and all of these things. So we made a number of recommendations about improving on that, so that there was one source, which really requires cooperation between various bodies to achieve it.
Yeah, indeed. And again, I can't imagine anyone would disagree with that. And we've all seen situations where that there hasn't been joined up thinking and things can fall through the cracks. So again, I imagine that most parties will be keen for that to happen.
Yeah, it's just finding the best way of achieving it. The most streamlined way of achieving it. And that's something that essentially it's something for the Crown and third sector organisations to develop, I think, between them.
Yeah.
In conjunction with the Scottish Courts and Tribunal Service, I think, who will have some degree of input of information, perhaps. But
of course. Another aspect of the report is with regards to enhance jury involvement and plans for more plain language to guide juries on the route to a verdict. And I think there was discussion about a pilot programme to communicate information to juries regarding certain rape myths and stereotypes, which I imagine could be quite a controversial matter, particularly, I know, speaking with colleagues, some people are quite exercised by this, and exactly what it is that's due to be or thought to be appropriate. Could you explain a little more about that?
Sure. Well, the report proceeded, the review proceeded on the assumption that we will continue to have juries in these cases for the foreseeable future. And if that being the case, we need to make sure that our communication with juries is clear, is plain, can easily be understood. We already have started during the jury trial restart after the first lockdown. We've already started with a degree of what you might call pre-instruction of juries, so that they get given more information at the outset about important concepts such as the burden of proof and the onus of proof and corroboration and so on. And so the anticipation is that that might be extended slightly. It seems to be working reasonably well. There'll be an increased focus on encouraging jurors not just to take notes, but to review those notes before they start their deliberations. And although judges already try their best to use plain language, it's all too easy for any of us familiar with the concepts to slip into bad habits. So greater focus maybe needs to be placed on that. As to routes to verdict, we didn't recommend any kind of what you might call a formal route to verdict, you know, in the format of a series of questions that juries have to answer. So question 1, and if yes, go to question 4. You know, we didn't see merit in that, at least at the moment. But we did think that there was a responsibility to provide in the charge a clear roadmap, so that the jury would know what it had to be satisfied of in order to convict. And that's what we are referring to when we talk about routes to verdict, not the more formalized kind of questions that sometimes are addressed. Now, the issue of myths that you raised, there was research, we've referred to it in the report, both from our own country and from elsewhere, suggesting that there are rape myths which may intrude on jury deliberations. The most significant ones, according to the research, that were more likely to intrude were that a person who has been sexually assaulted will always fight back, scream, shout for help, and that a sexual assault would be immediately reported. There's also, I think, an issue about showing emotion when giving evidence. But there was evidence to support the suggestion that these may intrude on jury deliberations, at the very least that jurors are uncertain what to believe about these. And if that is the case, then there's an issue that really requires to be addressed. There was actually little disagreement, as I understood it, in the group that these matters did need to be addressed somehow. The real question was about how you go about doing it. So there was a suggestion that it could be done by a video, a standard video shown to jurors just before they start the trial. That came from a pilot that's ongoing south of the border and is being looked at in Northern Ireland. Others, there were some who felt unhappy about the idea of something of that nature. Others felt that it should form part of the charge just as a matter of routine. Others that it should only be done in specific cases. And there was no conclusive research for us indicating the best way of communicating this information to jurors. That's why we suggested a pilot, but without specifying how the materials to be conveyed. It seemed to us that it will be necessary to look at the outcome and the evaluation of the pilot down south at anything which is done in Northern Ireland, who are, as I say, also looking at this, and to consult on the best way of achieving that without causing prejudice to the rights of the accused. So really, it's a recommendation that there should be further discussion and a pilot should be formulated as a consequence of that further discussion.
All right. I suppose the most controversial, if that's the right word, certainly amongst practitioners that I've been speaking to, is the consideration of a time-limited pilot of juryless trials for serious sexual offences. Can you explain why that was raised and how the rights of the accused are not compromised by that?
Well, taking the issues back to front, I suppose, the concept of a fair trial doesn't hinge on the involvement of a jury, either in this country or anywhere else. So it's perfectly feasible to devise a means of trial without a jury that is a fair one. As the report indicated, though, this is an issue upon which members of the review group were not unanimous. The point arose from a number of factors that we had considered. One was concern with juror understanding in these cases, highlighted in particular by the Scottish jury research, which is referred to in some detail in the report. There was also research in New Zealand, which suggested that cases of sexual violence might not be well suited to fact-finding by a jury. The report acknowledged that there are compelling arguments on both sides of this issue, but that there was sufficient evidence to suggest that there would be merit in considering a pilot of the kind referred to in the report. Clearly, if that were to be taken forward, detailed planning and consultation would be required to develop it fully, to address the kind of cases, to work out how the procedure would be and all the rest of it. And that would require discussion, consultation and development. But essentially, we felt that there are compelling arguments on both sides, and that meant that it wasn't an issue that could simply be parked. It was something that really did merit further exploration and discussion.
Right. In terms of the Scottish jury research, was that a kind of mock jury that was set up and people were asked about questions?
Yeah, that's right. We looked at that, and we looked at the research that was done in England with actual jurors as well. And of course, we looked at information from around the world. In particular, we were able to find some information from New Zealand, where they have been addressing or seeking to address similar issues. So we had a fair amount of information available to us to draw on.
And would that pilot scheme require an accused person to agree, to volunteer to take part? And would that be dependent on that?
That's something that would require to be determined. Obviously, any kind of pilot would require legislation to enable it to take place, and the precise terms of it, the conditions upon which it would proceed and so on, would all need to be worked out. So I don't think there's any way that you could, at this stage, specify what would be in, what would be out. It requires further detailed consideration.
Indeed. And again, my next question may be answered perhaps in the same way, but I suppose we hear regularly from the appeal court that we trust juries, and they are, an important part of our criminal justice system, that we rely on their wealth of experience and their combined knowledge. So I'm just wondering if that's the case, why would we want to remove them from the public from this process?
There's a particular issue with sexual offences, that if a juror is called upon to try a case of murder or robbery, it's unlikely that they have any direct personal experience either of murder or robbery, and therefore they should have no difficulty in bringing to the exercise the independence that they are expected to exercise and that a judge would exercise through professional training. Sexual offences are different though, because jurors have all got their own sexual experiences, their own attitudes and their own presumptions. And it may be a lot harder for them to set those aside when dealing with these kind of cases than it would be in other cases. And that may be what we see in the jury research, maybe see a consequence of that.
All right. Lady Dorrian, in terms of ILR, and that's another aspect that comes out of your review, I wonder if you might tell us a little bit about that.
Yes. Again, obviously, this is something that would require legislation to achieve, but the point here is really the fact that despite the rape shield legislation first being introduced nearly 40 years ago, 40 years next year, and its present iteration 20 years ago, we have seen a series of issues arising from the way in which lawyers and indeed some judges interpret the legislation, which has been the subject of numerous appeal decisions, particularly over the last 5 years, say. The present system depends on the Crown obtaining information from the complainer and deciding whether to oppose the application. And the problem is that there can be a tension between the private interests of the complainer and the interests of the Crown looking at the prosecution as a whole. And it may well be that those private interests should not prevail, but they need to be considered. The legislation requires them to be considered. Often we've had cases where the Crown have not opposed applications that should have been opposed. And generally we felt it was better in the interests of the complainer that their rights were properly recognised and to introduce ILR for that. It's anticipated that the application will be notified to them, and they may, and then it may be necessary for them to be represented. It may not be, it will depend on the circumstances. It would probably be necessary to allow the court to dispense with notification where an issue arises at trial to prevent delay in trial, and also anything under section 2759 would not be necessary to notify, because you can only restrict rather than expand under that section. But that's really the rationale, that the interests of the Crown and of the complainer don't always meet. And it can be difficult for the Crown as well, because at the same time as trying to put forward the private interests of the complainer, they have to look at what is in the overall interest of the prosecution. So having that separated seemed to make more sense.
Did I read something about a potential appeal in that regard by the complainer, or am I thinking of something?
Yeah, the suggestion is that it would simply be along the same lines as currently provided for, with leave only, right, and under section 74. Yeah.
Okay. So, Lady Dorrian, thank you so much for covering those various headings that arose from the review. I suppose that the last question that I have for you is, what now? How is this then taken forward, and who will be involved in consideration of the matters that have arisen?
Obviously, some of this will require legislation, which will be a matter for the Scottish Government. There are other proposals which could be introduced without legislation. That will be a matter for the Lord President, and it will also be a matter for the Crown and the Scottish Courts and Tribunal Service to look at whether there are any matters that they can introduce.
will the views of the of solicitors, advocates, those at the defence bar be considered in any of these matters being taken forward?
Well, I would imagine that, for example, with legislation, there'll be the usual process of development and consultation, which would make that appropriate. So I can only assume that that would be the case. Yes.
All right. Well, Lady Dorrian, thank you so much for your time. Great. And explaining it all to us. We're most grateful to you.
That's fine. So okay, no problem, Edith. Thanks very much.
Okay. Bye-bye.